American civil status U.S. law is private merchant law, leaving the people as surety and debtor on the national bankruptcy. Law is contract, universally and in the U.S., so we must follow the progression of contractual agreements, which constitute the underlying U.S. law. We cannot address all individual laws and cases, for it would take lifetimes to review them all, even though ignorance is no excuse of the millions of laws, statutes, codes, etc., in private admiralty jurisdictions. In basically chronological order, the following progression of contracts, and our interpretation of them, follows. The USA, a corporation of the English Crown, is bankrupt and has been since at least 1788. The Articles of Confederation states in Article 12, all bills of credit emitted, moneys borrowed, and debts contracted by, or under the authority of Congress, before the assembling of the United States, in pursuance of the present Confederation, shall be deemed as considered a charge against the United States, for payment and satisfaction whereof the said United States, and the public faith are hereby solemnly pledged. The Founding Fathers, as constitutors, acknowledged and reorganized the debt in the U.S. Constitution 1787, Article 6, hence the Constitution. Bankruptcy occurred on January 1, 1788, based on 21 loans that the United States of America received from the King of England dating from February 28, 1778, through July 5, 1782, the repayment of which had been ratified by Congress on January 22, 1783. The United States Bank, created in 1791, was a private bank, with 18,000 of 25,000 shares owned by England. No de jure, Constitutional Congress has existed since March 27, 1861, when 7 Southern states walked out of Congress, leaving Congress without a quorum for adjourning and therefore ending sine die. That which is called a Congress today assembles and acts under the authority of the President, acting in the capacity of being Commander-in-Chief of the Armed Forces, under emergency war powers rule, i.e., law of necessity, i.e., no law, and 31 CFR Chapter 5 500.701 penalties. Since the above-referenced date, March 27, 1861, Americans have been under fascist rule via presidential executive order under the aforementioned emergency war powers, 12 U.S.C. 95A, b. Every citizen of the United States is now legally established as an enemy via the Amendatory Act of March 9, 1933, 48 Stat 1, amending Trading with Enemy Act of October 6, 1917, H.R. 4960, Public Law No. 91. On December 6, 1865, the 14th Amendment was proclaimed as ratified.